Welcome to the summer webinar series on competency restoration, brought to you by the Texas Judicial Commission on Mental Health. I'm Molly Davis, a staff attorney for the JCMH. The Judicial Commission on Mental Health was established in 2018 with the mission to engage and empower court systems through collaboration, education, and leadership, thereby improving the lives of individuals with mental health needs, substance use disorders, or intellectual and developmental disabilities. Competency restoration is one piece of our work. Today, Judge Nelda Cacciotti and Ms. Alice Taylor will help us understand what to do when a person isn't competent to stand trial and isn't likely to be restored in the future. There's a lot to cover in just 1 hour. If you have a question, please put it in the Q&A box at the bottom of your screen. We'll take them up at the end if we have time. And now, please welcome Judge Nelda Cacciotti, the Chief of the Mental Health Unit of the Tarrant County Criminal District Attorney's Office, and Ms. Alice Taylor, the Program Manager at My Health, My Resources of Tarrant County, which is the local mental health authority in Tarrant County. I'll hand it over to you ladies now. Thank you.
Thank you. So good afternoon. We are excited to be here with you today. We're going to spend some time talking about everyone's favorite topic, defendants who are unlikely to restore or be restored in the foreseeable future, or perhaps they will never be restored. So an estimated 34% of Texas inmates have a mental health disorder. Over 1,900 defendants in Texas are waiting for a state hospital bed. Some of those were determined not restorable in the foreseeable future, or perhaps they failed to restore during their initial commitment for restoration. There are others that are in limbo because they were determined that they could not restore at all. These are very tricky situations and very tricky cases, and some are pretty difficult to handle. I think that we have all figured out by now that there's not a straightforward solution that applies across the board, but there are some options and alternatives to consider, which we'll go over in this presentation. So one thing I want you to keep in mind is that when you're dealing with cases where defendants have been identified with a mental illness or an intellectual disability or are incompetent, is that diversion is always an option, of course, in the appropriate circumstances. So once someone has been arrested, the code provides 2 opportunities to divert that person. One is after the defendant is identified as a person with mental illness or intellectual disability under Criminal Code of Procedure 1622, and the other is after a suggestion of competency or incompetency, I should say, has been raised under Chapter 46B of the Code of Criminal Procedure. So Article 1622 allows a court to release a defendant on bail while charges are pending and enter an order transferring that defendant to an appropriate court for court-ordered outpatient mental health services. There is a limitation in that the offense cannot involve an act, attempt, or threat of serious bodily injury. So let me see if I could advance here. Code of Criminal Procedure 46B allows a court to dismiss charges upon the state's motion at any point during incompetency proceedings after the issue has been raised. So at this point, any further court-ordered treatment would have to be under subchapter F, civil commitment with charges dismissed, which we're going to discuss a little bit later. So how is the issue of incompetency raised? A suggestion of incompetency can be from any credible source and can be based on observations alone. It is the threshold requirement for a judge to conduct an informal inquiry. So once there's a mere suggestion of incompetency, the court is legally bound to move forward on that competency route, unless, of course, the defendant is diverted from competency proceedings with a dismissal of the charges, like I just mentioned under 46B. So if a suggestion of incompetency is raised, then the court is required to conduct an informal inquiry to assess whether there's some evidence from any source that support a finding that the defendant may be incompetent. If the answer is yes, then the court must stop the case, stay all proceedings, and order a competency evaluation. So obviously the expert may find that the defendant is competent to stand trial, in which case the criminal proceedings would resume and they would proceed with a plea or a trial. But we're here to focus on those that are incompetent. So the opinion would be that the defendant is incompetent and either likely to be restored in the foreseeable future, unlikely to be restored in the foreseeable future, or will not ever be restored. And that last opinion can be stated in different ways. Different experts state it differently, but the bottom line is the defendant cannot be restored even with treatment and education, which leaves the state unable to prosecute that case. So if the opinion is that the defendant is incompetent and likely to be restored in the foreseeable future, that's pretty straightforward. You know, the code guides the court on commitment to outpatient competency restoration, jail-based competency restoration, or the state hospital for that initial competency restoration services, depending on what is appropriate for the defendant and what is available in your community. So what is competency restoration really? There's a legal definition that you can review in the code, of course, under 46B, but basically it's the treatment or education process for restoring a defendant's ability to consult with their attorney with a reasonable degree of rational and factual understanding of the court proceedings and the charges against them. And what does that really look like? Well, individuals who would be appropriate for basic competency restoration services may demonstrate a confusion about simple legal concepts. They may have a problem with naming the charges or the potential penalties or outcomes. Perhaps they're a little unrealistic about, the appraisal of those outcomes. They may have an inability to state the correct reason why they are in jail or why they're in the hospital. They could be exhibiting significant psychiatric symptoms or behavioral issues, or they may have a cognitive difficulty or intellectual disability. So the education piece is somewhat basic. For example, when talking about the judge and the role of the judge, it's explained to the defendant that, the judge is the person that oversees the trial. They sit in front of the courtroom, they wear a black robe, they tell each person in the courtroom when it's their turn to speak. They make sure that all the rules are followed in the trial and that the trial is fair. They also, may decide punishment, may decide what the defendant's punishment will be, or if the defendant chooses, to go to the judge for punishment after being found guilty. So the goal of competency restoration is to stabilize a defendant's mental illness symptoms, usually that's done with medications, and provide legal education so that the criminal proceedings can resume. So I think there's sometimes a misconception that competency restoration services equal intensive mental health treatment or, intensive IDD services, intellectual disability services. I've, sometimes heard attorneys say, well, this, particular defendant really needs some mental health treatment. So let's have them ordered into competency restoration. I think that a defendant will receive some mental health treatment if they're ordered into competency restoration services, even if it's just by way of them getting medications, but it's not the same thing or at the same level that they would receive in a therapeutic environment. Competency restoration services is not comprehensive mental health treatment. And it's important to understand that. It's more like a triage as opposed to intensive care. So sometimes we get the opinion that a defendant is incompetent and unlikely to restore in the foreseeable future. Why might that be? Well, it could be due to their diagnosis. Perhaps they are diagnosed with a neurocognitive disorder or disease that is degenerative in nature, like dementia or Alzheimer's. Perhaps they suffered from a traumatic brain injury or they've suffered from strokes in the past that have resulted in cognitive impairment that is affecting their ability to restore to competency. They perhaps might have an intellectual or developmental disability and are low functioning, so they're not able to restore because of that. I've also been told that, long-term non-compliance can lead to a longer road of stabilization. So perhaps, their illness is pretty severe. Maybe they're resistant to treatment. Prolonged substance use may impact a person's ability to restore within the foreseeable future, along with certain medical issues. So these are just some of the reasons why someone might not restore to competency, either in the foreseeable future or at all. So if I see an opinion or get an opinion that a defendant is unlikely to restore, whether that's within the foreseeable future, or perhaps they had a failed attempt at restoration, or they're just non-restorable, they're not going to restore no matter what, the first thing I'm going to do is look at the offense and the facts of the case. Are there any community safety concerns, victim safety concerns? What is the state's interest in prosecuting that case? Do we have a compelling reason to move forward? To me, there is a difference between pursuing charges on a defendant that has a case of serious aggravated sexual assault of a child or murder versus a criminal trespass, criminal mischief, or even a low-level felony case. A low-level felony drug case, that is. So that is going to be one of my driving factors that I consider in my decision to pursue a civil commitment with charges pending or resolve that case in some other way. Also, I'm going to look at what the experts say. What did the expert who initially evaluated the defendant for competency conclude about restorability or the length of time that it would take to restore? I might also look at whether the defendant has previously been ordered to competency restoration services in the past, and if they were successful. In reviewing the criminal history, I might note that there are prior recent charges that were dismissed because the defendant was incompetent to stand trial. Now, that information may not always be available to me, but if it is, that's something I'm going to review and consider. And I'm also going to factor in the defendant's behaviors. What have the defendant's behaviors been like while they've been in confinement or in a competency restoration program? Are they exhibiting behaviors that rise to the level of civil commitment? Are they endorsing suicidal ideation or homicidal ideation? Are they exhibiting behaviors that would indicate that, they are a danger to self or others, or meet that third deterioration criteria? That they have deteriorated to the point that they cannot care for themselves without court-ordered treatment. Also, have they been actively engaged in their treatment? Are they medication compliant? Have they stabilized to some degree, improved in any way? So those are the things that I am going to consider in determining, what my next steps are when I see this opinion. So if the state has an interest in prosecuting, there's a possibility of restoration, there are community or victim safety concerns, then the state can pursue a civil commitment with charges pending under subchapter E. We often refer to this as a 46B 102 or 103 order. And it's applicable if the opinion is that the defendant is unlikely to restore in the foreseeable future, or they failed to restore after initial commitment for restoration, like in a JBCR program or even at the state hospital. So I want to point out a distinction between a defendant that there's an opinion that they will not likely be restored to competence, and one that they will not likely to be restored to competency in the foreseeable future. Foreseeable future is talking about the initial restoration period described in 46B 071, 072, and 073. So in this case, perhaps with a longer time in restoration services, the defendant may restore. But non-restorable opinion is that even with extended treatment and education on competency material, that is not going to help achieve competency, maybe because of their diagnosis or for some other reason. So it's in that situation that we need to seek, or at least consider, alternative dispositions. So that could include a dismissal of charges for civil commitment and some others that we'll go over here a little bit later. So for civil commitment with charges pending, if it appears to the court that the defendant may be a person with mental illness or intellectual disability, then the court proceeds with applying the criteria, the civil commitment criteria, under Chapter 574 of the Texas Health and Safety Code. 574 is for mental illness, or also Chapter 593, which is for intellectual disability. So keep in mind here that the criminal court maintains jurisdiction because the charges remain pending. So it's the criminal court that is applying the Health and Safety Code criteria. And I'm going to briefly go over this commitment criteria because I have mentioned it, that the person has to meet civil commitment criteria in order to be committed under subchapter E and also subchapter F. So 574 again is for mental illness, and basically the state has the burden to prove by clear and convincing evidence that the proposed patient is a person with mental illness, and that as a result of that mental illness, they are a danger of serious harm to themselves or to others, or they have deteriorated to the point that they cannot care for themselves and they're unable to make a rational and informed decision as to whether or not to submit to treatment. There are two types of civil commitment. There's a temporary commitment and an extended commitment. The difference here being the length of the commitment, and also with an extended commitment, it requires a couple of extra criteria that must be met. So for long-term placement, if an individual or defendant has a mental illness, then they would be proceeding under 593 of the Health and Safety Code, and that's long-term placement. So the state would have the burden to prove beyond a reasonable doubt that the proposed patient is a person with intellectual disability, and because of that intellectual disability, the proposed resident represents a substantial risk of harm to self or others, or is unable to care for their most basic needs, and that the facility is the least restrictive setting for that proposed resident, and the facility provides the services appropriate for the proposed resident's needs. So these are the different relevant statutes that apply to civil commitments that I just went over the criteria. Again, there are options for temporary and extended inpatient and outpatient treatment. So Health and Safety Code 574.034 is temporary inpatient. 0345 is temporary outpatient. For extended inpatient, which is a longer commitment period, it's 574.035, and extended outpatient is 574.0355. Residential care for those with intellectual disability, long-term placement is Health and Safety Code 593.052. So sometimes we get an opinion that a defendant remains incompetent and they have timed out or are timing out. This could happen after restoration was attempted via a program like jail-based competency restoration, or initial commitment at for competency restoration services at a state hospital facility. A defendant could also time out while they're waiting to participate in competency restoration services after being ordered. So perhaps they're waiting for a state hospital bed and they time out during that time of waiting, or they're waiting for a spot in a local program to open up and they happen to time out before the space opens. So the concept of timing out in this circumstance, you're mostly going to encounter for misdemeanors, sometimes also lower level felonies, like perhaps state jail felonies that carry a maximum punishment of 2 years. The defendant cannot be committed for a cumulative period that exceeds the maximum term provided by law for the offense for which the defendant was to be tried. So how does that work? Your cumulative period basically is equal to or less than the maximum sentence provided by law, which is comprised of all the time the defendant was held in jail before and after they were ordered to competency restoration services, plus any time the defendant participated in those competency restoration services or waited to participate, and any good time credit the judge gives, but that's up to the judge. It's in the judge's discretion to give that good time credit. So there's actually a provision in 46B.010 that provides for a mandatory dismissal of misdemeanor charges on the state's motion if the defendant was not tried before the expiration of the maximum period of confinement for competency restoration. And if it so happens that the defendant is still in need of court-ordered treatment at that point, then the case would have to be dismissed and transferred for civil commitment proceedings under subchapter F. So civil commitment with charges dismissed, how would that work, or what would that look like? Basically, upon dismissal, the criminal court is going to determine, is there some evidence to support a finding of mental illness or intellectual disability? And if the answer to that is yes, then the criminal court shall transfer, so it's required, they transfer the defendant to an appropriate court for civil commitment proceedings. It's important to note that the defendant would remain detained in jail or can go to any other suitable place, which could include a responsible person while they wait for those civil commitment proceedings to be initiated and take place. And to be committed, again, the defendant must meet that civil commitment criteria in the Health and Safety Code. So in this situation, the criminal court transfers jurisdiction of the defendant over to an appropriate court. Was typically it's your court with probate jurisdiction. So the criminal court would no longer have jurisdiction over that case or that defendant. So civil commitment with charges pending can be, civil commitment with charges dismissed can be pursued when the defendant has timed out or is likely to time out. It can also be used as an alternative disposition when there's opinion that the defendant is not likely to restore, either whether that's within the foreseeable future or at all. Additionally, you can dismiss it for civil commitment if the defendant has failed to restore within their initial competency commitment, and at any point after the issue of incompetency has been raised. Also, if they're exhibiting behaviors that indicate they meet civil commitment criteria, and if the state is willing to dismiss. So again, here, the criminal court is transferring jurisdiction of that defendant for these civil commitment proceedings. I think this is a good time to talk about presumptions. We know that the defendant is presumed competent until proved incompetent by preponderance of the evidence, and that burden lies with the defense. However, the presumption of competency and that burden can shift. So let's say a defendant is facing charges, but he was found incompetent on a previous case that was resolved. So on that previous case, if there was a formal finding by the court that the defendant was restored to competency before the case was disposed, then on the new case, the defendant is presumed competent. The standard burden of proof, preponderance of the evidence, applies. But let's say that on that previous case, it was disposed without a formal finding that the defendant had restored to competency. So they remained incompetent at the time that the case was disposed. So on the new case, then the defendant would be presumed incompetent, and the burden would shift to the state to prove that they are competent beyond a reasonable doubt. So sometimes we get an opinion that the defendant is incompetent and cannot restore to competency and also cannot be civilly committed. So people tend to want to hit their head against the wall in this situation, and with good reason. These are the hardest cases to deal with for several reasons, one of which is that some of these defendants are charged with pretty serious offenses that the state absolutely has an interest in prosecuting, but because of the opinion and the circumstances, the state can't. So what do we do here? Well, one thing to keep in mind is this is a challenging population, and with this population, it can be quite challenging to find suitable alternative dispositions for many of them. Many are high utilizers. It's the whole concept of the revolving door. They're in and out of our jail system. They're in and out of our hospital system. Many are symptomatic. They may have a refractory disorder. As we mentioned, they don't meet civil commitment criteria. Perhaps they're refusing to engage. They're not always the best about medication compliant. They may have a serious charge pending that the state has concerns about it and wants to leave pending. Perhaps they're self-medicating with drugs or alcohol and have little to no supports often and are unhoused. So all this to say, it takes time and special attention and serious collaboration to find an appropriate alternative disposition for some of these defendants. So when considering alternative dispositions, you want to collaborate with your local mental health authority and any other stakeholders. Collaboration here is really key. There are even other agencies that you can collaborate with to help find placement or plans, alternative dispositions for these individuals, like Takumi. Defense counsel can be very helpful in coming up with alternative dispositions for people. So the first thing to do is consult with your local mental health authority or your local intellectual and developmental disability authority, your LMHA and LIDA, to figure out what are the available treatment and services and resources in our community that are going to meet a particular defendant's needs, and also that are going to address any concerns the state or court may have. Defense counsel can provide information on whether the defendant has a support system in the community, like family or friends, whether they have a place to go, if they have any medical needs, whether they have an ability to make bond, and whether the defendant is willing to engage or has been engaging in treatment. Your local mental health authority or your LIDA, can help with placement in a group home or a nursing home. They often will talk with family and the defendant to determine, what that person's needs are, set up connection to programs to meet those needs and services to meet those needs. They can help with restoring benefits and help with establishing a way for the court and parties to get updates on progress or how the person is doing in the community if that's necessary and asked for by the court. It's also important to always communicate with all the stakeholders. So the parties, your opposing counsel, your local mental health authority, local intellectual and developmental disability authority, whoever you're working with, and the court all need to be on the same page and all need to be on board with whatever alternative disposition you are looking at. And also, once you do come up with this plan and have everything in place, make sure you ask the court to enter in release instructions to a specific person, whether that's with the LMHA or the LIDA or a family member, on a specific date and time. The last thing you want to do is to have a great plan in place only for the defendant to get released at 2 a.m. out to the streets, and now they're MIA. So here are some examples of alternative dispositions that we have done when we've had defendants that are not restorable and also not civilly committable. Of course, this is not an exhaustive list, and I always tell people you're going to have to get creative and don't be afraid to think outside the box. So one thing you could do is dismiss with or without a release plan. Well, what do I mean by release plan? So again, I just talked about, figuring out what the defendant's needs are and what community services, programs, resources you have available to meet those needs, so that you can connect that person with treatment services upon their release from custody. This can help down the road with reducing recidivism in that revolving door. Perhaps they need to go into a residential, placement or treatment like a crisis respite unit or substance use treatment. It may be that they just need an appointment at their clinic that they used to get services at, and so that they can reconnect with their provider and continue on with medications or restart their medications. Many times they're going to need housing, or at least a connection to housing. So perhaps that's a group home, family, or, if it's a shelter, it's a shelter. So another thing that can be done is the person can be released on bond with treatment conditions. Again, those treatment conditions are going to look very similar to what your release plan might look like. So, it might be, reside in a group home and follow all those rules of the group home. Follow up with your mental health provider, take all the medications as prescribed, and follow any outpatient treatment recommendations, counseling, substance use, whatever their needs are, plus any conditions that are related to the offense, for community safety purposes, and to ensure that they'll appear in court if they're going to have court appearances. Of course, if they're already on bond and are engaged in treatment, well, then the case can just be dismissed if that is something that's being considered. If you have a jail diversion center in your community, which is very helpful, you can transfer to the jail diversion center so they can get connected with treatment and services that way. Some folks, need long-term care. So they perhaps the, opinion of the expert, or, when they were receiving competency restoration services, believe that this person has medical needs that rise to the level of needing nursing home care or memory care facility, and that can be worked out. Your local mental health authority is a great place to start with helping for obtaining placement for those individuals. I can give a number of examples from over the years that MHMR Tarrant, our local mental health authority, and other agencies like TACUMI have helped us place people that were incompetent, not restorable, and did not meet civil commitment criteria. And it was because of this collaboration that we were able to come up with an alternative disposition for a person. There's one example that I can think about. It was a kind of a very sad case in the sense that this was a defendant who was elderly and had been diagnosed with dementia, had never experienced mental illness before, and did not have any criminal history. And he happened to commit murder. And he murdered, allegedly, a family member. So he was in custody. He was not restorable, not civilly committable. And we reached out to our local mental health authority to help us find placement for this individual. And it was, pretty difficult to find placement for him because of his charges. Well, defense attorney, we started collaborating with that defense attorney, and he was able to contact family. Family was, willing to post a bond and find placement in a nursing or memory care facility that they were going to pay for. And the state was willing to, agree to a lower bond and agree to this alternative disposition so that he did not languish in jail. So, but again, the case was going to remain pending. That's not a case that, the state was willing or in a place to dismiss at that time. So thankfully, with that collaboration, it worked out. Another one that we had that was charged with a pretty serious offense, our local mental health authority got involved and could not find placement here in our community. Again, because of the violent nature of the charge, it was pretty difficult to find placement for him. So we ended up reaching out to TACUMI, and TACUMI was able to find placement out of county for that individual. So it took collaboration with our local mental health authority, TACUMI, the state, defense, and then we had to also, approach the court, get the court on board with setting a bond and getting all that in place and allowing him to move out of county to a nursing care facility. So thankfully, with those collaborations, we were able to find alternative dispositions that all were comfortable with. So it's always also a good idea to set up a process for a warm handoff to your local mental health authority or your LIDA or even family to at least set them up with a connection to services and leave custody with medications. I prefer this much more to just dismissing someone to the street, because at least they can get some sort of connection to services. And in these cases that I gave you examples about, or cases where, defendants are placed on bond or released with a release plan, sometimes the case is left pending for a certain period or maybe for a long time. Sometimes they're dismissed once, the state and court, everybody is comfortable that, they're doing fine in the community, they're doing what they're supposed to, they haven't picked up any new cases. But it just depends on the charges, the facts and circumstances of the case. So in considering appropriate alternative dispositions, I suggest keeping certain objectives in mind, like, making sure that any concerns, any state concerns or court concerns are addressed, making sure that the defendant is being connected with treatment and services, making sure that community safety is being considered, and engaging that defendant with treatment so that that can lead to reduced recidivism. I mean, that's the idea, is we're hoping to stop that revolving door, stop that high utilization of hospitals and jails, and creating a greater impact, community impact, lowering costs, reducing crime, making better use of our resources in the community. So it's very important to get familiar with the resources and programs that are available in your county. I've included a picture that shows the catchment area of the local mental health authorities and behavioral health authorities in Texas. If you don't already know who is your local mental health authority or behavioral health authority, find it on the map and reach out to them. Also look for programs that are available in your community that might not necessarily be under your LMHA. We recently found out about a program in our area called the Cowtown Clubhouse. We had no idea this program existed here, and it's been in existence for a couple of years. And apparently there are clubhouses all around the nation. And it was by happenstance that we actually became connected with Cowtown Clubhouse. But it ultimately led to us talking to the executive director, touring the facility, figuring out and finding out all that they can provide for their participants, and collaborating on ways in which defendants who are being released from custody can connect with their program, and maybe even be a step down for those that are releasing from the hospital. So my biggest piece of advice is make a point of contact at your LMHA and any other programs you have available in your community that could be used as a resource. Build a relationship. Relationships are so important. And so it's important to build a relationship with someone at your LMHA and your LITA in these area programs that you can call, text, with questions, collaborate with, get their input on, suggestions, recommendations. I promise you, it helps make life so much easier when handling these difficult defendants in difficult cases. And it just so happens that Alice Taylor with MHMR Tarrant is often that person for me. So I'm going to turn it over to her so that she can tell you about all the great things she and our local mental health authority do for our justice-involved mental health population in Tarrant. So Alice.
Yes, hi. Thank you everybody for coming today. I'm very excited to share with you my knowledge and the things that we've done in the past here. And thank you, Judge Cacciotti, for the information you've provided today. So again, my name is Alice Taylor. I am the program manager for outpatient competency restoration here in Tarrant County. And let's just jump right into it. So the goals here when working with people who are not restorable, is to ensure the patient's needs are met, that we're doing our best to support them in the community to reduce that recidivism, to keep community safety in mind, Ensuring the participant or the patient is an active participant in the services and to provide support to the families. So many of the families that we work with may not have a good working knowledge of mental health or the mental health system. So ensuring you can provide that education to them and support them through this journey has been really helpful for us. So some common needs that we see based on different diagnoses, for those with mental health diagnoses, housing, medications, we often will refer to other programs that have intensive services or specialized services like home and community-based services, ACT, FACT, substance abuse treatment, and counseling. Making sure that we are connecting them with their medications, with follow-up appointments, make sure that they can get some kind of income, whether that's working or Social Security, to maintain any housing that we may obtain for them, medical insurance, and PCP. So many of these individuals not only have a mental health diagnosis, but also medical needs that need to be addressed that could impact their wellness overall in the future. For those who are diagnosed with an intellectual and developmental disability, housing is always paramount. Medications, if they have any, ensuring that we're referring to the LIDA and referring to specialized services like home and community-based services, ICF homes, and refer to guardianship services if needed and if applicable. And for those with neurocognitive disorders and TBIs, again, housing is really, I think we all feel this across the state, is a really big struggle. So most everybody that we work with do need housing. Sometimes we get people who may be deemed non-restored, but they don't have that official diagnosis of neurocognitive disorder. So we assist them and their families in getting those appointments to get those diagnoses, so we can submit those records to the court. And then connections with memory care facilities. Many memory care facilities require them to be medication compliant before they enter the facility and have a way to pay for that facility, which can be a really big barrier. And we will get into that in some of my later slides. So what's my process? So once I've gotten the referral, I conduct a face-to-face interview with the individual and identify those needs. So I'm going to be asking them, what are some things that you need if and when you get released, if they are in custody. If not, we'll continue that conversation on an outpatient basis. I also check databases that I may have access to see who their contacts are, if they have any history of violent behavior or substance abuse or any medical needs. And this is especially helpful for those who are poor historians. So once I've identified community supports, I then contact those supports to see if they are willing and able to assist with the needs that the patient has identified. And they'll locate those community resources. So if it's a nursing home, I start making calls. If they're going to be residing with family, I start, making those connections, making those calls, and then referring to other programs as needed. I make sure to communicate the plan that we have established with our legal partners. So John Doe is going to be going to such and such nursing home. They're available to take him on this date at this time. I have requested the medications so that these transition plans can be approved in a timely manner. And I always make sure to let our legal partners know what the time frame is. If that is not made clear and if it cannot be agreed upon, your patient may lose their bed space at whatever facility you have selected for them. And then the last step is to implement that plan. And you're like, wow, 6 steps, that's great. But these can take months and months to establish. especially the housing portion, especially those who need nursing facilities and like ICF or HCS group homes. There's oftentimes wait lists for those. And so my release process, once the plan has been accepted and we're ready to go, I inform the court, like this is for sure the plan, about a week in advance. Make sure I'm communicating the release time, that I have transportation from the jail to wherever they're going set. And then the day before, I'm confirming the housing. Hey, is that bed space still available? Can they come and live with you? We're still good on that. One day prior, here in Tarrant, we have the ability to request the psychiatric medications that they have been prescribed while in custody. So I request that 24 hours prior to release. And then start communicating with the release desk saying, hey, John Doe's going to be released tomorrow around this time. I'll call you to make sure that we can get that time slot we have requested. Because sometimes, depending on where an individual may be housed, it may take longer for them to get down to the release desk, get processed, and there are other steps that the jail has to take to ensure a seamless transition. So I always like for them to have a heads up of when that's going to happen. Pick up the medications and make sure you have it in hand when you're getting that defendant out of jail. And then we also provide a change of clothes, hopefully 2 or 3 if we have them, and a hygiene kit for their release. So common barriers, lack of available bed space in our local group homes. So group home is an option, is probably the most common and readily available option, but sometimes they get full, especially when the summers are really hot, when the weather is bad, when it's getting really cold outside, those group homes tend to fill up. And when that occurs, one thing I may do is reach out to home and community-based services. If their benefits have not been disconnected, they must have active straight Medicaid to go into home and community-based services, or reach out to some local shelter programs to see if they have a space available. And this will help the individual to not have to wait outside of a shelter to get a bed space. Difficulties reinstating benefits is probably one of the biggest barriers that we see. I'm finding it's taking 6 months or more to get those benefits reinstated, which is a real hindrance to those who need to be placed in some kind of care facility, like a nursing home. Wait times for bed spaces with HCBS, HCS, and ICF group homes. You can request from the coordinator of these programs emergency placement, which has been a pretty viable option that I have found over the years. You can normally get a bed space pretty quickly in Tarrant if you request emergency placement. Memory care facilities, they limit the types of charges or severity of charges that they will accept. And so that can be really difficult for our clients who have higher level felonies. They require med compliance and the ability to pay. And that's really difficult because as soon as you step foot into the jail within 30 days, typically your insurance and your income is cut off. And so that can be a real challenge in trying to get people from custody or even the community to a memory care facility. One solution I have found with this is being proactive in identifying which facilities will take your higher level charges. We've had to look outside of the county and ensuring that we're getting ROIs for these facilities so that we can be transparent with them about what these needs are, because you don't want to place an individual and then all of a sudden the facility's doing their checks and they're saying, oh wait, that bed's not available, or they have to leave, they can't reside here anymore. Also, it is really important, especially for those that go into a nursing home, to identify some family member, if available, who can access that individual's financial records, because the nursing homes will require some kind of proof of finances. And we as case managers, of course, can't call a bank and say, hey, give me John Doe's bank statements. They're not going to go for that. Okay, so memory care facilities typically won't take individuals without an ability to pay. So trying to get those benefits turned on as quickly as possible. If you get ahead of the game, it's not, in my experience, not always something that happens, but if you're able to get ahead of the game, when a person is in a state hospital, that state hospital should be able to assist the individual in applying for their Social Security and Medicaid benefits. And so we can at least have that application pending if they return to the jail as not restorable or still incompetent. It applies in both cases. We can also look to see if family is willing to take them for a period of time until a memory care facility is available. I am transparent with families in having these conversations, in that this is not something that will likely occur in a month. This isn't going to be, 30 days and then we have them in a facility. It could, but it's not likely. So being transparent about asking them, about what they're going to be signing up for. And then for those who have a low baseline of functioning, of course, connecting with the LIDA, identifying family who may be willing to apply for guardianship. Here in Tarrant County, when you apply for guardianship, you have to complete or have a physician complete a CME stating that this person's not able to care for themselves, and a suggestion of need letter. And then that gets turned into the probate court, who will hear the case and then make a decision on whether or not somebody is in need of a guardian. For your atypical cases, so these are things that just don't come up a whole lot for me, but things I've worked with before, people who are out of state. So for those, I have been able to find family who's willing to take them. And this takes a lot of coordination with the courts to ensure that you're getting a release time that works. So, we've put them on a bus or a train. I've never put anybody on an airplane before, because they have to have identification to get on a domestic flight. And a lot of people, we can't prove that they do prior to release. But making sure the family can buy the bus ticket for, point A to point B, that train or bus is leaving at this time. I need them out by this time. And then taking them to that train or bus to make sure they can get their ticket and get on that train safely. Ensuring that the family is going to be there to meet them once they get to point B. Do they have the proper identification? I know with Greyhound, if you don't have proper identification, the family member who purchased the ticket can set up a password for the defendant, so they can go up there and be like, hairbrush, and they can get their ticket to get on to the train. And again, careful coordination of the release time. For people who may not have citizenship, this can be especially difficult because they do not qualify for services that would allow them to have some type of financial stability in the community, like Social Security. So we've worked with them in getting their application for a green card in, which is a very lengthy process. And the applications can be hindered based on criminal charges and diagnoses. I have learned that there are lots of waivers that can be signed for cases, and those will be reviewed by a judge. And then sex offenders, you have to ensure that the housing that you're locating for them is appropriate. So not by parks, not by schools, and that the environment is appropriate. So a lot of individuals who may have charges involving children, and sometimes not, they have they're only allowed limited access to like TV, cell phones, internet. And so finding a group home that will work with those conditions can be a challenge sometimes. And then understanding the process for registering as a sex offender when applicable. So always, communicating with your local police office about how they move through that. Oh, I skipped a slide. There we go. All right, so an example, transition plans. Hope we have some House of the Dragons fans in here. So Damon T is a 48-year-old male diagnosed with schizophrenia and high blood pressure. He's charged with assault and theft of property. He was recently opinioned to be not restorable by a psychologist. He reports that his wife, Rhaenyra T, will not allow him back home and provides her contact information. He agrees to mental health treatment in the community and is willing to continue taking his long-acting injectable and other medication. Damon states that he was receiving SNAP, Social Security, and Medicaid before his arrest. So for a case similar to this, I would confirm with Rhaenyra the address that he would be residing at, and then how is he going to get home? So in this case, Rhaenyra is unable to provide transportation because she is really busy at work. And so case manager or a van driver or Uber or Lyft, if you have that available to your agency, will provide the transport. Making sure that medications are ordered in a timely manner and sent to the pharmacy. Here in Tarrant, we have them sent to our clinic. That a psychiatric follow-up is scheduled, that you ensure that the medical follow-up is either scheduled or that information is provided to the individual, and then additional referrals made as needed. So for this case, we're referring to Social Security, counseling, SUDS, and assigning him a case manager. And questions?
I'm so glad that you're open to taking questions because we have some for you.
Fantastic.
Yeah. Alice, what options would you recommend as an alternative to guardianship, like supported decision-making or anything else beyond that?
I guess it depends on what the needs are and what the goal is, but you could consider powers of attorney, but those limit the family member's ability to be of assistance.
Yeah, I understand that. It's a rough situation for everybody to be in. And we do have a question about Tacomi, and I think actually both Judge and Alice can jump in on this, but if the case is dismissed, so for a person who could not be restored, and this person does not have other criminal history aside from the event that landed them here, can Tacomi still assist that person?
Yes.
I think so, yeah.
Great. And is the right path for that like through the state agency or through the LMHA, or how can we get there?
So I think it depends on how the Takumi grant is written. For any individual LMHA here in Tarrant County, referrals are made from probation and parole to our Takumi programs.
Okay. That's my understanding as well. All right, folks. Our friend Sonia Burns has noted a number of concerns. We're always grateful for that as well. But she says that there is a Senate Finance meeting or a hearing on September 5th. So if you're interested in these issues at the legislative level, you might want to tune in then. I do want to thank you all for attending today. We had well over 300 people on the webinar with us, which I think is amazing for the state of Texas and our dedication to helping people with mental health needs. Thank you to our experts, to Judge Cacciotti, and also to Ms. Alice Taylor. We are so thankful for your time and for your expertise. To our audience, watch your email in the next day or so for a copy of the PowerPoint slides. You are getting all of them. And also some information on claiming your continuing education credit. you will get a certificate of attendance if that is helpful for your licensing body. If you want even more training on mental health law, registration for our annual summit is now open. You can register with a link that's going to be dropped in the chat here momentarily. We have a great program again this year, including our keynote speaker. Y'all, you don't want to miss this. It's attorney Robert Canino from the Dallas area. He is going to be talking about his experience protecting the human rights of people with IDD. It's really, really exciting. So that link should be popping up right there. And if we don't get it in time, then it will definitely be in the email you're going to see later today or tomorrow morning. And that's all. Thank you again. Y'all have a great day. Bye-bye now.
Thank you. Bye.
Thank you.